A federal appeals court is pushing back on part of Idaho's controversial library law. Last year, a judge in Boise refused to block the law from going into effect, but now the higher court says part of it likely violates the First Amendment. Aspen Chumber joins us in studio. And Aspen, both sides are claiming victory today. How is that even possible?
Well, Morgan, supporters say the law is still in effect and they can live without this one provision. Opponents say that one provision was the most dangerous part.
In the case of Northwest Association of Independent Schools et al. Versus Labrador.
Last November, attorneys squared off before a 3-judge panel at the Ninth Circuit Court in Portland. They debated Idaho's Children's School and Library Protection Act, or House Bill 710, which requires schools and libraries to remove material deemed harmful to minors or face lawsuits. A coalition of Idaho private schools, a library, and a church sued, arguing the law is so broad it threatens books that are constitutionally protected.
This statute imposes real burdens on the schools that we represent who are not intending in any way to use obscene materials and want only to use those materials that they've used year in and year out to educate their students.
The law's supporters say the state has every right to shield children from harmful material.
This statute is the statute that Idaho uses to prohibit giving straight up hardcore internet pornography to minors.
This week, the Ninth Circuit panel issued its opinion. The judges called a key provision, quote, overbroad on its face and says it threatens a substantial amount of expressive activity. That provision is the context clause, a phrase inside the state's 50-year-old definition of harmful to minors. The clause lets courts decide whether a book has value based on where and how it's being used. But the Ninth Circuit Court found that's too subjective. The case now goes back to U.S. District Court in Boise with orders to block that one provision, but the rest of the law remains in effect. Idaho Family Policy Center helped draft the law and calls it a win.
The plaintiffs, the libraries, were asking the Ninth Circuit to block the entire law.
The Family Policy Center's director, Blaine Canzotti, says parents can still see a book they think is harmful, file a complaint, and the school or library would have 30 days to remove it or move it to an adult-only section. If they don't, parents can still sue for $250.
The Children's School and Library Protection Act is good to go. It can remain in effect and can continue protecting children from harmful materials in schools and libraries.
But the coalition that brought the lawsuit sees it as a win for them, saying without the context clause, schools and libraries have a stronger legal defense if they're sued, because they can argue a book has serious value without the state second-guessing where or how it's being used.
In a statement to KTVB Tuesday, Reverend Jenny Hurst with the coalition says, in part, quote, this is a win in everyday terms because the most harmful parts of the law aren't being used. A federal judge in Boise will now determine how to shape that injunction or how far it goes, which could determine what this law actually looks like going forward, Morgan.
Okay, so clearly far from over. Aspen, thank you.